And as we say in page 23 of our briefs, they simply cut off the negotiations without ever raising those concerns. But to be clear, if that's a concern, sweep that into the ban too. Put in that non-sensitive technical data into the ban too. We'll deal with that. It's a lot better than simply being forced to shut down. So that is most definitely a less restrictive alternative that would address data security. We talked about the under-inclusiveness and Temu and Shein, the two large e-commerce sites. Justice Kagan, you might have seen Temu during the Super Bowl. It was heavily advertised. It's one of the most popular e-commerce applications in the United States. It's got 70 million users. Justice Sotomayor, you were asking what they collect. This is from Joint Appendix 339 to 343, the U.S.-China Economic and Security Commission Review Report. Shein relies on tracking and analyzing user data, draws on customer data and search history with the assistance of artificial intelligence algorithms. It requests users share their data and activity from other apps, including social media. So they apparently go into your social media apps and suck up all of the information. Because they're e-commerce apps, they take names, addresses, and credit card information. If you look at the privacy policies on their website, they collect location data. It looks like they might even collect, at some level, GPS location data. So they collect massive amounts of data. Point 3. Their mere covertness argument makes no sense for the reasons that the court explored. If mere covertness were the issue, a disclosure would make perfect sense. Yet they're not concerned about mere covertness. They're concerned, as my friend suggested, with getting Americans to argue with each other. Well, you know, as far as I can tell, that's what news organizations do in this country every single day. That's what we call editorial content. That's what we call content itself. And so it's trained directly on the content. But even if you thought somehow that the mere covertness were the issue, that definitely could be addressed through a risk disclosure. So the data sharing ban, the risk disclosure, those are obvious, less restrictive alternatives. And had the government considered them and rejected them, we would be in a different position. But if you look at this record, those are two less restrictive alternatives that the government did not address at all. Whether you apply strict scrutiny or intermediate scrutiny, that is fatal, because under both standards, restricting speech has to be the last resort, not the first one. And when you fail to consider less restrictive alternatives, you fail under either standard. My final substantive point is we absolutely think this court has the authority to enter an administrative stay. I didn't understand my friend to disagree with that. We think that given the enormity of this decision, given the complexity of this case, it would make perfect sense for this court to enter an administrative stay. I also think you could enter a preliminary injunction. Yes, likelihood of success is one standard, but you don't have to determine ultimate success. And as you do in other related contexts, like with respect to stays, you often make clear that you are not addressing the merits of the case. I think you could do that here. The bottom line, Your Honor, is this case ultimately boils down to speech. What we're talking about is ideas. And my friends on the other side, when you cut through everything else, are ultimately worried that the ideas that appear on the TikTok platform could in the future somehow manipulate Americans, could somehow persuade them, could somehow get them to think something that they ought not be thinking. Well, that whole notion is at war with the First Amendment. If the First Amendment means anything, it means that the government cannot restrict speech in order to protect us from speech. That's precisely what this law does from beginning to end, whether you look at its text, whether you look at the government's justifications in its brief, where they talk about being worried about speech criticizing our leaders or undermining democracy. It's what you see in the House report, which drains specifically on the dangers of misinformation, disinformation, and propaganda. And it's what you see in this legislative record writ large, which is saturated with objections to TikTok's existing content. We ask that you reverse the court below. Thank you.
Thank you, counsel. The case is submitted.